Welcome to MK True Crime. I'm Phil Holloway. I'm a criminal lawyer, I'm a former prosecutor, and I'm a former police officer. I have been in and around the justice system for the better part of 40 years now, and I know a great true crime show when I see one, and that's what we have today. So here's what's on our MK True Crime docket. We're in week 3 now of the Kouri Richins murder trial. This week, business partner and best friend of the alleged victim, Eric Richins, his name's Cody Wright, he took the stand to testify about Eric's alleged drug use. Was this a major flop for the defense? We'll discuss. And later, we will be joined by criminal defense attorney Natalie Whittingham-Burrell, aka Natalie Lawyer Chick on YouTube. She'll be with us to discuss the 911 call played in court and one of the most memorable witnesses yet to take the stand in this humdinger of a trial, the Kouri Richins trial. Also, here in Georgia, where I am, a teacher was killed tragically during a prom season prank. Now, his students are charged in his death. Should they be held responsible? We'll bring you all the details. I'm very pleased to be joined today by my friend, my co-host, Diamond Dave Aronberg, the Florida lawman, former state attorney for Palm Beach County, Florida, and the managing partner at Dave Aronberg Law. So, Dave, we're in the 3rd week of the Kouri Richins trial, and we've had some interesting witnesses take the stand, including Eric Richins' business partner and friend, Cody Wright. Cody testified on Monday about a call Eric made to him on Valentine's Day in 2022. Cody said there was fear in Eric's voice. Context, however, for the call was omitted from the testimony, but we can provide that here. According to multiple court documents and prosecutorial allegations in her ongoing murder trial as of 2026, prosecutors claim that Richins laced a sandwich, her husband's favorite, with fentanyl and left it for him in his truck with a Valentine's Day note. Reportedly, Eric ate a bite and then he suffered a severe reaction, including hives, trouble breathing, and blacking out or losing consciousness. This has been described as a failed attempt to kill him, about a month before his actual death in 2022. From what prosecutors say was a lethal dose of fentanyl slipped into a Moscow Mule, that being 5 times a lethal amount. Now, with that in mind, let's go ahead and play Cody's testimony on the call. Shot 1.
Do you recall receiving a phone call from Eric at approximately 2 p.m. on Valentine's Day, 2022?
Yes.
Without saying what Eric said to you, why is it you remember that phone call?
The fear in his voice, the urgency of the situation, the seriousness of what was going on.
Had you ever heard Eric sound like that before?
The only other times I heard that urgency and that fear when he called me telling me that his mother had passed away in the hospital. I also heard that urgency or that fear when he had been rear-ended in an accident, and feared that the person that had hit him had passed away as well, or had hit him hard enough that he was scared of what had just happened.
All right, Dave. So look, I've got thoughts about this, but the first thing that comes to mind is this is why I have my Whiskey Tango Foxtrot mug. For those of you who are listening on podcast or on Sirius XM, that's what my mug says, because I don't know WTF they are thinking by not including all this very important context here. I mean, my God, she is accused of trying to kill her husband on Valentine's Day by poisoning his sandwich. And then the friend gets this call on Valentine's Day, and he said there's something off. I mean, you heard the video and the audio. There's something off with the man's affect and his demeanor on the phone call, like he's scared. Why not bring in that context, Dave?
It's the hearsay rule, Phil. So Cody Wright can testify that Eric called him and that he sounded fearful, distraught, urgent, all these things. They can describe Eric's vibe but they can't repeat what Eric actually said to them because that would be inadmissible hearsay. So if Eric said, I think Kouri just poisoned my sandwich, well, that would be hearsay. So you can talk about how Eric sounded. You can talk about how he, the witness, felt, but you can't talk about exactly the words that Eric said.
No, you're right about the hearsay being the proper objection, of course. Now, I can think of, to play devil's advocate, I can think of another way to maybe get those words in. You basically, offer the words, the exact words spoken, and you tell the judge once there's an objection that you're not offering these words for the truth of the matter asserted. Judge, I'm offering them for the effect that it has on the listener, right? And some judges might allow you to do that on that basis, but the judge, being the gatekeeper of what's fair and what's not fair, this is solely within the judge's discretion. But I suspect, Dave, that we're going to hear more context about this as the trial moves forward, because remember, she's accused of that attempted murder. And also you can get into prior bad acts if they denote something like someone's criminal signature. So if your criminal signature is you like to poison people with food, then this clearly fits that bill.
All true. Now, there are exceptions to the hearsay rule, as you correctly noted. If it's a present sense impression, an excited utterance. And so those are ways you can get it in. And if you can't, and it's objected, well, it's hard to unring that bell. The jury has heard it. So I agree with you that there's a way to make sure that the jury gets the context. I mean, it is really damning when you have someone like Kouri Richins saying her husband is a drug user. He poisoned himself through drug use. When, hold on, didn't you try to poison him previously on Valentine's Day through a sandwich? And then, of course, I'm still wondering if she tried to poison Grossman, the boyfriend.
Oh, the hush puppy. Yeah, hush puppy. We talked about that last time. Good question. But, if you're the prosecutor, and you've been a prosecutor a lot longer than I was and more recently than I was, but still, even I remember that as a prosecutor, you don't want to have to try your case twice. In other words, if you get a conviction and if it's overturned on appeal because you put in some inadmissible hearsay, then you've got to do the whole thing over again. Or perhaps you don't want to risk a mistrial. And by the way, as of day 10, Monday, March 9th, there's been 2 formal written motions for a mistrial. I think we don't have to spend a lot of time on this, Dave, but I don't think those mistrial motions really amounted to much. One of them had to do, the defense moved for a mistrial after, the witness mentioned jail calls in front of the jury. Now, look, and the judge said that that was relatively innocuous. And I agree, because everybody and their brother knows that if you're on trial for murder, you either are or at some point have been in jail. So that's really innocuous. And then on March 2nd, the defense moved for a mistrial regarding alleged undisclosed information concerning witness Carmen Lauber, who, by the way, was the housekeeper who was allegedly charged by Kouri Richins with procuring, I shall say, the drugs in question used to allegedly murder her husband. The story, the idea was that, all the information about this witness and her not doing so well in her drug court rehabilitation program, she didn't do well and she may have been sanctioned. Look, here's the thing. If she wasn't doing well in the drug treatment court, maybe, just maybe, it's because Kouri Richins had her out there scouring the countryside for any and all manner of drugs. That's just my opinion. I welcome yours.
Well, yeah. I mean, that's how she got the drugs. I mean, this is a key witness. She had this hookup with someone who had some drug issues, and instead of helping her through her own recovery, she asked her to get her the good stuff, the Michael Jackson stuff. So they have so much evidence against Kouri Richins. I think the most you can do is just to, bat her eyes at the jury and be all like the doe-eyed look of innocence. And she's there dressed very wholesomely and wearing no makeup, and just maybe get some jury nullification. Maybe there's one juror who feels sorry for her, doesn't want her to go to prison. I mean, she was ready for this moment. She dressed in those pajamas that made her look like a sweet young woman when the cops came to her house, and it was videotaped after her husband was poisoned to death. So, she is she's trying, even though the evidence is clearly stacked against her.
Well, we've got some more testimony from Cody that I want to talk about with you. This prosecutor Bloodworth asks Cody about a series of beneficiary changes made to the New York life insurance policy in January of 2022, just months before the alleged murder. And the life insurance policy, these guys were business partners, obviously, and it's not uncommon for people who are business partners to have insurance on each other and things like that. Cody says he did not make the changes, and he did not make any changes to Eric's policy. Let's check out SOT 2.
Are you familiar with a buy-sell agreement that you and Eric had in place should anything happen to either of you?
Yes.
Are you familiar with a New York life insurance policy, a set of New York life insurance policies that were associated with that buy-sell agreement?
Yes.
Are you familiar with the series of beneficiary changes to the New York life policy on your life in January of 2022?
I was told those happened.
Did you make those beneficiary changes to your New York life policy in January of 2022?
I did not.
Did you ever make any beneficiary changes to that New York life policy?
No.
Did you ever observe Eric Richins make any beneficiary changes to that New York life policy?
No.
Here we are, Dave, they're hammering home the financial motive behind their theory of the case.
Yeah, it's also the financial charges. I mean, she's being charged for some of these financial improprieties as well, for this fraud. So it's a twofer. But jurors always want to know the why. You don't have to. It's not an element to a murder charge to know why someone did it, but jurors want to know motive. And here, the motive is easy to understand. She wanted the money. She was deep in debt. She fell out of love with her husband. She had a lover, Grossman, on the side. She wanted a new life. Done. You got it. You got means, motive, opportunity. I guess the only thing defense has left is just to tarnish the victim, just say that he was a drug addict. And, that was a big part of the whole testimony with Cody Wright, trying to show that Cody Wright wasn't so honest about his testimony. He lied about the Red Devils. And therefore, the defense lawyer told the judge that means Kouri Richins is innocent.
Oh yeah, let's talk about, okay, so let's I'm glad you mentioned the so the Red Devil thing. All right, let me sort of set this up for the audience. There's this discussion between the defense and the prosecution about drugs, okay? Defense lawyer Nestor believes that she can impeach Cody. Now, impeachment is where you try to show the jury that the witness could not be believed because they're either a liar or they're mistaken, or for whatever reason, their testimony is not credible or believable, right? So she says that she can impeach Cody because, according to her, she didn't tell the truth about Eric's alleged drug use. And judge says he's not sure it's in fact something that's impeachable, but if it is, then she can do so. But the judge isn't sure that Cody has said anything that is impeachable. Nestor referring to a transcript from what Cody said in the preliminary hearing and something about Red Devils. Now, I don't know about you, Dave, but I don't know that I've ever used or heard the term Red Devils, but this is all something that supposedly took place way back in high school, more than 20 years ago. So its temporal relevance to this whole thing is sketchy to begin with, in my view. But let's go ahead and listen to SOT 3, and then I want to talk with you about what we learn that Red Devils actually are.
Was it your understanding in high school when you knew about this that Mr. Richins was using his own prescription for pain pills or someone else's?
I learned about this later on in life, not in high school.
Okay, and what did you learn?
And I learned that he had taken pain pills in high school. That's what I had been told.
Without a prescription?
I didn't get asked whether there was a prescription or not. I don't know.
All right, and then I think you said in the prelim that you thought they were called Red Devils, is that right?
That's what I was told.
And was it your understanding that Red Devils were an illicit street drug?
I don't know what an illicit street drug entails, but I assumed that the Red Devils were being abused, as that's what high school kids were doing.
So people were doing that in your school.
I heard that, yes,
And did you know what red
later
devils?
on in life.
What did you know what red devils were?
I learned later on what those were, yes.
What are those?
I believe it's Sudafed.
Oh, it's Sudafed.
I think. I'm not a drug person. I'm sorry.
Oh, I could bring up my Whiskey Tango Foxtrot mug again, Dave, because we've seen instances in this trial where maybe lawyers were surprised by the answers, but now we've got Sudafed being compared to illicit drug use, not to mention, by the way, the torrential inpouring of the hearsay that we were talking about. It's almost like hearsay coming through, like water through a fire hose here. What's going on?
Yeah, why did the prosecution allow so much hearsay in there? But here's the thing. It is important if the victim here, Eric, had used illicit drugs, because that is the whole theory of the case for the defense. But what we're finding is that you have a witness who's very close with Eric, who said that he has never seen Eric use over-the-counter or prescription drugs. He has never seen Eric use illicit drugs. And then he sort of contradicts that by saying, well, there's those red devils that he knew about those. And then it turns out red devils is Sudafed. Then people abuse Sudafed back in high school. I don't know, but it is impeachable. That's something to impeach a witness to say, okay, well, I caught you. But the defense lawyer tried to take that a step further and say, not only did I catch you in a lie, this entire witness testimony should be thrown out. My client is innocent. No, you're taking maybe a small victory you got, instead trying to say you won the Super Bowl because you made a 10-yard gain on a running play in the fourth quarter when you're down 31-0. That's my sports analogy.
You said a step too far. I think it was like a mile too far. By the way, we have the sound and the video of Attorney Nestor moving to strike all of Cody Wright's testimony on the basis of all that Sudafed nonsense. Let's see what the judge says. Sot 4.
On our strongest way possible, we object to this. We would like a continuing objection. We move to strike all of Cody Wright's testimony. All of the issues that Mr.
Whoa. You lost me
on
there.
on redirect. The redirect testimony.
Which
Where,
piece?
where he answered the question that I'm not now being allowed to impeach him on. We're asking to strike it at the very minimum. All of the things that Mr. Bloodworth just brought up all go to weight, not admissibility. And
What is the non-hearsay route for this witness to testify regarding what he heard if it's coming in for the truth of the matter asserted?
it's not. It's coming in to impeach that once the court allowed him to answer that question with hearsay, to rebut the hearsay that we elicited unintentionally.
What's the evidence that he heard prior to today, testifying today, that Eric Richins used illicit street drugs?
He just testified to it on the stand.
That is not true.
Okay, well, we agree to disagree on that, Your Honor.
All right. So let's just, for our audience benefit, I'm sure the lawyers who are watching this show or on YouTube are going to probably eviscerate me in the comments because I'm not going to do this like completely right. But hearsay is a complicated topic. Basically, it's an out-of-court statement that's offered for the truth of the matter asserted. So if you want to bring in a third-party statement that says the sky is blue for the purpose of proving the sky is blue, that's what it means, offering for the truth of the matter asserted. But if it's brought in for something else other than to prove the truth of what is being asserted, then it might be non-hearsay. It may fit into some exceptions to hearsay. Now, that's what, when the judge says, what's the non-hearsay way to bring this in when it's being offered for the truth of the matter asserted, because the judge is just as confused as I am. Here's what the basis of my confusion is, Dave. She says she wants to impeach this witness, which we've talked about a moment ago, which is to try to say that his testimony is somehow not reliable. There's limited ways, though, that you can impeach someone's testimony. You can impeach them if you have evidence of that witness saying something different at a previous time, that's called a prior inconsistent statement. If you can prove that they said something different on an earlier date than what they're telling the jury now, that's a way of impeaching. If they're a convicted felon, you can bring in their felony conviction and tender that to the jury and show that they're a convicted felon, therefore they're not worthy of belief. And there are, very limited, but, impeaching by hearsay. I've never heard of hearsay being admissible for the purpose of impeachment. Please correct me if I'm wrong, but am I missing something here?
You're absolutely right. You can't use hearsay for that purpose. Cody did not have firsthand knowledge of Eric using Red Devils as an adult. He was relying on some high school rumors. So to throw out his testimony because that is a bridge too far. You could, because you got it in there, you could say, I'm to members of the jury, we impeached him. We showed you can't believe things they're saying. Now, even though two things can be true at the same time. He said he never saw Eric use drugs. He didn't know of Eric using drugs, but he had heard the rumor back in high school. So, okay, you got, like I said, maybe you get a little something out of it. Defense lawyer, good job, move on. But now you go to the judge, you say, strike the whole thing, and the judge is incredulous. In fact, the judge sent the jury out of the room and gave a legal lecture to this lawyer saying that you're trying to use hearsay to impeach hearsay. So remember, the original source of the drug rumor was not in court, so it can't be cross-examined. So the defense can't use these rumors to make Cody look like a liar.
If you are looking to make smarter choices for your health this year, consider Riverbend Ranch. Their steaks are not only delicious, they also contain real, high-quality protein that helps fuel your body. Beef is a complete protein and contains all 9 essential amino acids your body needs to function. It also keeps you fuller for longer, reducing cravings and snacking. But here's the key. Not all beef is created equal. The quality of the beef depends entirely on how it's raised and where it comes from, and that's where Riverbend Ranch stands apart. For more than 35 years, Riverbend Ranch has been building an elite Black Angus herd, carefully selecting cattle for exceptional flavor and tenderness. All Riverbend Ranch cattle are born and raised right here in the USA. They never use growth hormones or antibiotics, and the beef is processed at the ranch in their award-winning USDA-inspected facility. No shortcuts, no middlemen, just incredible, healthy, and flavorful beef shipped directly to your home. Order today at riverbendranch.com and use the promo code Megan to get $20 off your first order.
All right, Dave, before we move into our next block where we have our guest joining us to pick up more on the Kouri Richins trial, I want to come back closer to home here in Georgia where I am. I don't know if you saw this story, but we had a tragic situation here over the weekend. A Georgia teacher sadly lost his life after teenagers' prank went wrong. So this happened late last Friday night. A group of teachers in Gainesville, Georgia, drove to one of their teachers' homes. They were armed with rolls of toilet paper to toss over the trees as part of a good-natured prank. It's called TPing, or we used to call it rolling the houses when I was a kid. So the teacher knew this was coming. This was a long-standing tradition at this school, but the ground, unfortunately, was slick from rain, and the teacher, who, I guess the way the rules were set up, Dave, the rules of this prank contest, if you were able to TP the teacher's yard, you get a certain number of points, but if you get caught in the process, the teacher gets the points or something like that. Jason Hughes, age 40 years old, slipped and fell as he was trying his best to catch them in the act, so to speak. He fell in the street and was sadly run over by one of the teenagers, 18-year-old young man leaving the scene. Now, all 4 of the kids involved in this have been charged with various crimes, but the worst of it was the driver, Ryan Wallace. He's accused of running over Mr. Hughes. He's accused of felony, Dave, homicide by motor vehicle, because it's based on reckless driving. Now, interestingly enough, and I want to hear your thoughts on this, interestingly enough, the family does not want him to be prosecuted. The family of the deceased teacher understands that, in their opinion, this is a tragic accident, and that the late teacher, the victim in the case, would not want the kids to be prosecuted. Dave, that brings up prosecutorial discretion, and there's nobody better than Dave Aronberg to talk to us about that and how that plays into this case.
Well, the wishes of the victim's family will matter because apparently the students had no malicious intent. The teacher knew about this. They all loved each other, and this was part of the junior-senior class wars. And if the teacher caught them when they were TPing the house, and then they lose points, and that explains why they were in such a hurry to drive off before the teacher could come out. But then the teacher slipped and fell, and he was accidentally run over. So this is such a tragedy. The only thing is that the school district had previously called upon the students to end the prank war tradition because students had taken things too far previously. And so they said, don't do it. And they did it anyway. So should there be a criminal charge here? Well, normally I would say there's something here, but if the family of the victim says, we don't want to compound the tragedy. I mean, we've already lost our loved one and we don't want to see kids have their life ruined. They're already obviously saddened and just destroyed by this, by having blood on their hands. Does it mean justice to prosecute them further? I don't know. I think perhaps they should at least lower the charges, maybe come up with a resolution and end this tradition because this has clearly gone too far.
Well, reckless driving is a misdemeanor traffic offense in Georgia, but it's the predicate for the felony variety of vehicular homicide. There's a misdemeanor variety of vehicular homicide, but the felony variety relies on some underlying serious traffic offense like reckless driving or DUI or something along those lines. And to prove reckless driving, they would have to prove that this young man was driving in a way that he just utterly disregarded the risk that he was posing to the public, such that it endangered life or limb. And the evidence, apparently, according to the family, was that the reason that the victim was in the roadway to be run over was because he slipped on wet ground. So we will have to keep following this here at MK True Crime to see how it's going to play out. I actually posted something about that on X because there's actually a GoFundMe now, not only for the victim's family, but for the kids who are being now supported by that victim's family in terms of their efforts to not face criminal charges. All right.
Well, yeah. Well, the one student faces up to 15 years in prison if convicted. Yeah. So, yeah, serious stuff.
Yeah. Well, it's one of these things where he's going to have to live with this for the rest of his life. And I can clearly see where a fair-minded prosecutor might take the wishes of the victim's family into account. And even if they don't dismiss these charges, significantly reduce them. There's a misdemeanor variety of this. There was no criminal intent, and it seems to be a prank gone wrong. And all the schools around here do it. Coming up next, we have criminal defense attorney Natalie Whittingham-Burrell, a.k.a. Natalie Lawyer Chick, on YouTube. She joins us next to dig deeper in the Kouri Richins trial. Think about this. In 2006, $20,000 equaled roughly 33 ounces of gold at spot price. At today's prices, those 33 ounces would be worth about $165,000. That's why smart Americans diversify a portion of their savings into precious metals. And that's why you need to consider buying gold from my friends at Birch Gold Group. For thousands of years, gold has been a store of wealth, and today it's a crucial part of any balanced strategy. Even better, Birch Gold can help you convert an existing IRA or 401k into a tax-sheltered retirement account in gold. Just text MK to the number 989898 to receive your free info kit on gold. There's no obligation, just useful information. With an A+ rating with the Better Business Bureau and tens of thousands of happy customers, let Birch Gold help you diversify with gold. Now that's peace of mind. Again, text MK to 989898. Again, text MK to the number 989898 today.
Welcome back to MK True Crime. Joining us now, criminal defense lawyer Natalie Whittingham-Burrell, a.k.a. Natalie Lawyer Chick on YouTube. Check her out. Welcome, Natalie. And as a criminal defense lawyer, what is your assessment of the Kouri Richins defense team so far in this trial?
Thank you so much for having me. So I think they leave a bit to be desired. I will say on a positive note that they are coming across as quite dogged, which is good because she's facing the most serious charges that you can face. They're not slouching off and kind of tucking their tail, but there could be a bit more in the way of organization and the way in which the questions are being asked. I'm really taking a lot of issue with.
Yeah. By the way, I'm with you. I mean, they don't have a lot to work with, though, right? I mean, you're an experienced criminal defense lawyer. I mean, what do you do in a case like this where it seems like you have a mountain of evidence against you? You've got means, motive, opportunity, and do you try to object as many times as this lawyer has been objecting? It seems like she's just annoying the jury by the constant objections, and her tone with the judge has been a little caustic. So I don't know. I mean, what do you do when you have trash as a case and you try to snatch victory from the jaws of defeat?
Oh yeah, I think the tone with the judge is definitely where you don't want to go here. That this is an instructional what not to do. The judge has a great affect, and he's very respectful to everyone in the courtroom. And the fact that they are repeatedly trying his patience is not boding well for Miss Richins. You poke holes where you can. And so I don't really take so much issue with the objections, but make the objections be good. Do the objections where they count and where they matter most and where you're trying to preserve a record. And when it comes across as though it's excessive or gratuitous, you certainly can lose the jury that way. So
Yeah, you don't want to waste the jury's time, Natalie, as you know, because they will hold that against you very much when they go back into their deliberations. You know, we've seen a lot of objections. We've seen a lot of questions, though, that were asked that shouldn't have been asked, and we've seen answers given to some of those questions that the defense lawyers weren't even expecting. And I was curious to get your take on some of that aspect of the advocacy here. Everybody's got their own style. I get that, and I'm not trying to be overly critical, but it seems like there's been more than one instance here, multiple times now, where these lawyers just walking into a bee's or a hornet's nest of an answer that they weren't expecting.
yeah, they're opening the door quite a lot, right? They're opening the door to bad evidence that would not have otherwise come in. They're also opening the door to snarky answers from witnesses that almost make the attorney seem like they're not as up to snuff as they should be. I especially think of the private investigator who has worked for defense attorneys many times.
Yeah.
And they keep asking him questions to speculate to the state of mind of law enforcement, which he knows not to do. You should know not to ask a professional witness those types of questions, and it comes across as disingenuous, and it makes the jury question, your capacity to have a case of this nature. So it's not, that part is not working.
I want to get to, you're right about that private investigator. We're going to get to some of his testimony in a minute, but I want to go back and ask you some questions about the 911 call evidence that's played. Can we hear SOT 7? And then let's actually do 7 and 8 back to back if we can.
Okay, tell me exactly what happened.
I don't know. I was sleeping with my kids.
Okay, I can't understand you. I need you to take a deep breath. What's going on?
I don't know. I was sleeping in with my kids. I just came in our bed, and I turned over, and he's just cold. He's just cold.
Who's cold?
My husband. I turned the light on.
And he's not breathing? You better lay him on the floor or the ground, on the floor on the ground?
I'm just shaking. I can't touch him. I can't.
You can do it. You can do it. You need to calm down, okay?
He's just yellow.
We need to help them. I can guide you through CPR. Take a deep breath for me. I'm here with you.
He doesn't have a pulse.
So did she or did she not do CPR, Natalie? Because, I don't know that anybody asked any of the witnesses whether it was apparent that actual CPR was performed.
I didn't hear the question asked, and it doesn't sound like she performed CPR on the 911 call. As we all know as legal professionals, when someone's performing CPR, it's a violent act. So there will be evidence of it if it's performed, and also you can hear a person performing it. She is hesitant, doesn't want to perform CPR when she says she doesn't want to touch him. So I would really like to know that. Did she even attempt CPR with him?
Well, so yeah, I mean, I think that those kind of follow-up questions, like, we've talked about this before, some context that sometimes just seems to be missing from this case. But Dave, I know that when you were a prosecutor, you were an expert with these 911 calls, and you knew how to tell juries exactly what they mean.
Well, I mean, every case is judged by its own situation. And here you have someone who, I believe she delayed calling 911. I don't think she called right away. And here she is as someone who was told to do CPR, and she didn't, apparently. Also, it is telling, and I don't know if it came in the context of the first poisoning attempt, but when Eric called her to tell her that he feels so sick, and she knew allegedly at the time that he had been poisoned, she encouraged him not to go to the hospital, just to go sleep it off. So I think all that in context shows that these are crocodile tears. And that's something that jurors hate. They hate someone who's trying to fool you, trying to put one over on you. And I've seen that a lot in my career. You have these defendants who just, they're a damsel in distress. Well, I think the 911 call does not help her, but maybe Natalie, you think differently, or you are an experienced criminal defense lawyer, and so you're able to pull rabbits out of the hat.
Yeah, well, her crying in that 911 call actually reminds me, as a defense attorney, when I have a state's witness on the stand who's lying and saying, oh, they did this to me, they did that to me, and it's crocodile tears. That's exactly what that sounds like. The same exact tone of voice. It's very disingenuous.
Right. And that's something, I mean, jurors just want to be respected, that like, we're here to be a fact finder. And when you have someone who's looking at them with the doe eyes and, dressed really very plain with no makeup from the stand and just looks so sweet, how could anyone like this do that? It reminds me of the Menendez brothers with their soft sweaters, or the Nicholas Cruz, the massacre, the killer at Marjorie Stoneman Douglas, with the sweater and the big oversized glasses. Defense lawyers know how to dress up their clients.
Jodi Arias, right?
Yeah.
Well, look, speaking of cold-blooded killers, there's been a twist in this, and I want to set it up and then ask you about it. So we have the lead investigator, Detective Jamie Woody, now a canine officer here in 2026. Also, by the way, somebody that you might have asked the question to, hey, did you see any evidence of CPR actually being performed? But there was this issue that came up. All right, so you have Eric's sister named Amy, right? So apparently at some point, Amy told the Detective Jamie Woody that Eric had told her that he thought that Kouri was going to kill him. Now, that's obviously hearsay and hearsay within hearsay, but we've got some sound, SOT 9, and some video of Detective Woody discussing this.
Mr.
I'll
Blood,
just ask the question.
Yeah, ask your next series of questions. Let's see where we go.
When Amy met you in the driveway, did she say anything that informed your investigation?
Yes.
What did she say?
She told me that Eric had said to her that he thought Kouri was going to kill him.
Then did you go into the house?
Yes, I did.
Okay, so this, Natalie, appears to be obviously outside the presence of the jury.
Yeah.
So
I hope so.
Yeah. So that's why there was no objection, but they're clearly, the judge is trying to go through the sort of the legal analysis to determine whether it can come in and what it's all about. But what's your take on that piece of this and the legal issues, Natalie?
Well, my take on it is that, first of all, it's hearsay within hearsay, blanket. That she could have taken action in conformity with, but I don't see how a jury would be able to put that aside if they did hear it. But if in fact he did believe that his wife was going to kill him, that's pretty damning. That places in context her behavior around that time and whether or not it's innocuous behavior, as her lawyers would want you to believe, or if it shows that she was actually plotting to kill her husband. If the very subject of the plot felt like they were going to be killed, maybe she was plotting to kill her husband. So it informs us as the viewer of something.
Well, the judge asked Catherine Nestor if she wanted to ask Woody about the exchange, and Nestor said based on Woody's report, there were 2 conversations with Amy. Nestor asked when Amy spoke with Woody, which of the conversations did she mention that Eric thought Kouri was going to kill him in? And Woody says in both conversations. So, if you're the prosecutor, I can understand why you might want this information to come in, but I also understand as a prosecutor why you wouldn't, because as you mentioned, it's hearsay within hearsay. And it's the kind of thing that even if you could figure out some way to rationalize its admissibility, it's one of those things where its danger for unfair prejudice against the accused outweighs the probative value. The probative value of it is pretty low, particularly since you can't cross-examine the purported speaker, Eric. That's just my take on it. But I want to also ask you, Natalie, about another witness, quite the character in this case, Todd Gabler. I'm just going to ask you now an open-ended, non-leading question. What do you think about Todd Gabler, and who is he?
Wow, I thought Todd Gabler was very, very interesting. He's the investigator that mostly, I think, almost exclusively worked for the defense, then ended up finding all this information that he handed over to the police that informed them going back into the home and doing more searches and finding more evidence that was incriminating towards Kouri Richins. And I also thought that on cross-examination, I mean, he was just a gold mine for the prosecution. He anticipated the purpose of the defense's questions, exposed the purpose of the defense's questions to the jury in answering the questions. Like,
Yeah.
you want me to speculate, but I'm not going to do that. I disagree with your characterization. I mean, goodness gracious, I would have hated to have to cross-examine that man if that was my case.
Well, I've talked about this before. It's, you got to ask pointed leading questions that you already know the answer to, or a witness has the opportunity to do that. So here's SOT 10, Todd Gabler, discussing the hundreds of texts between housekeeper and purported drug procurement agent Carmen Lauber and the defendant Kouri Richins.
Was there any particular contact weight that caught your attention?
Yes.
What contact did that involve?
It involved the contact with Carmen Lauber. I noted immediately that there were many hundreds of text messages between the two from the initial data set. That was January of 22 through May of 22. There was a very heavy weight. I don't recall if she was the second or third weight, but it was very close. The only 2 people that I recall that were ahead of Carmen on that weight was Kouri's mom and Eric. It was immediately apparent to me that Carmen had a very extensive criminal record involving drug use and potentially drug sales. I noted that Carmen had a dirty urinalysis, meaning that she tested positive for prohibited drugs in her drug court around the time of Eric's death. I was very concerned about the high number of contacts and the criminal history for Carmen, and I alerted the sheriff's office about that.
So it's the large volume of text that he says piqued his interest in this case, Natalie.
Right. Yeah. And it's interesting because Carmen has a relationship to Kouri Richins and her family that is a professional one as a cleaner So one could argue from the defense perspective that there's a completely innocuous reason for the large amount of contacts, but you have to look at an overall history. And if the history is that they were not contacting each other that frequently, and then leading up to Eric's death, they're contacting each other all the time. And then she's supposed to be in recovery, she's in drug court, and now all of a sudden she's testing, dirty, that would absolutely be a subject of concern. And also why, if this is the witness that made that connection to Carmen based on those contacts, I would have been a lot more careful in my cross-examination of him, because that's a very intelligent person. He is very, very good at drawing, connecting the dots to each other. And so it just was such a perilous witness for the defense, this gentleman.
This guy was such a good witness. He was very popular on Twitter, and for good reasons. I mean, he comes out of Central Casting. His voice is strong. He's got the cane, so it's like a little mystery. It's like got a little Matlock in him. What's interesting is that also he's been a private investigator for 34 years, and he's worked on 100 homicide cases, and in every case it was for the defense. He has never before been on the state side, but he felt so compelled by what he saw that he's testifying for the state here. Boy, that is so powerful.
Natalie, I don't know if you saw this, but there was one part of his testimony where, I don't want to say it. Let's just listen to it. Let's SOT 10.
And then you drove it to a locksmith.
I did.
And you busted into the safe.
I did not bust into the safe.
Well, he did.
He bumped. He used a technique called bumping. It's the movement of the door and the frame of the safe that allows it to come open.
Okay, but you didn't have a combination.
I don't know if that was a combination. I thought there was a key to that one.
It was forced open with a hammer, right?
I think it was a rubber mallet, and it was dropped onto the ground.
Okay.
I think that's what eventually got it opened, was that it was dropped onto a flat surface.
And when you were doing that, there's no law enforcement there, correct?
I don't need law enforcement to babysit me.
Okay.
So again, this could have been avoided by the defense with shorter questions, more pointed questions, and not, with doing it that way, they would not have given him the room to just take it and run. We know that the safe was opened by some alternative means, right? Why do we need to quibble on whether it was a hammer or a mallet or if it was bumped or dropped? What was the point in all that, guys?
She's losing the forest for the trees. So what she's trying to get at is, you obtained this evidence by some nefarious means, and so we should not trust this evidence, right? You weren't being watched by law enforcement. You could have gone off on your own and just done something, and so we can't trust the evidence that comes out of it. You, as the defense attorney, need to realize where a certain battle is lost, right? He is extremely experienced. He works mostly for the defense. He's not motivated to help the prosecution. And so the implication that he somehow tainted the evidence or did things in an incorrect way, he's going to take offense to, and then make you look, excuse the term, dumb for trying to imply that he would do that. In that cross-examination, he looked like, if you've ever seen a cat play with a mouse when the cat is not really hungry, he was just kind of batting her around just now on cross-examination. And she allowed that, like you said, through those open-ended questions on details that ultimately were not going to matter.
Yeah. Phil, all good points. And the way he does it is just such a burn. I mean, that's how you can make someone look dumb, and you never have to excuse yourself for saying the four-letter word dumb or any other four-letter word on this channel. But I said it reminded me of Matlock. Actually, it reminds me of Ironsides. I don't know. Natalie's too young for that, but Phil, you and I probably remember Ironsides, right?
Oh my God. Yeah, of course. I mean, don't date me too much, but yeah, Ironsides. The only thing missing is the wheelchair, right? But
the neck brace.
He does have the neck brace. But there's one other thing that really stands out with this witness. Natalie, I'm sure that you're familiar with the whole, is this or is this not sexting? And by that, this is between Bryce, Eric and his friend Bryce. What was that all about?
You know, honestly, this is once again losing the forest for the trees, right? Because who cares? You're not trying to say that someone else, he was having an affair and someone else killed him, right? That's not what we're saying at all. We're trying to say it was a genuine accidental overdose. What does it matter if Eric was or was not sexting or having an emotional affair? Are you trying to, throw your deceased person, your victim, under the bus? That's not going to help you. So I have no idea where she was going with that. And it did not pay off. Well,
Nestor, defense attorney Nestor, asks about these texts, and she asked Gabler to review it. The witness says it's a joke, right? But Nestor asks about a text exchange between Eric and his friend Bryce that said, quote, "Kouri and I are starting an open relationship tonight, so I told her I'm taking you home." And then there's some other things that, apparently were of a sexually suggestive nature, but also the kind of thing that's, may not be uncommon between friends who are sending a otherwise private text conversation. In fact, let's hear SOT 11, which is Gabler discussing this.
Do you remember seeing this text between Eric and another individual saying that Kouri and I are starting an open relationship tonight? Right?
It says, "Kouri and I are starting an open relationship tonight, so I told her I'm taking you home."
Right.
Yeah.
Okay. And you left that out of your report.
No, this would be part of my report.
Did you see sexting between Bryce and Eric when you looked at their texts?
I don't recall that, no.
Katie?
And is this sexting? I don't know what you mean.
No, I'm not talking about this one.
Okay.
I'm talking about other ones.
All right. I don't recall.
Before Dave takes us out of the segment, I just got to point out that this, in the law, there's a technical legal phrase for this, and it goes like this. What does that have to do with the price of tea in China? It's not relevant.
Exactly. If before I go, I'll just say, maybe if he had in fact left it out of his report, you could say, you're very biased because you care about Eric for some reason. You feel really, really sorry for him. You're trying to paint him in the best light possible, and you don't want to believe that he overdosed, and so now you're blaming Kouri, right? Why that would be the case, who knows? But he did put it in his report, so why are we talking about this?
Because they've got nothing else. They're just grasping at straws, throwing anything against the wall, hoping something sticks. But yeah, it's not going well for them. That's why they need you, Natalie, to take over the case. But fortunately, we've got you here, and we're going to find you on YouTube. So, Natalie, where can our audience find you?
You can find me on YouTube at Natalie Lawyer Chick.
Natalie Lawyer Chick, thank you for being here. That's Natalie Whittingham-Burrell. I'm Dave Aronberg. That's Phil Holloway. And next is our closing arguments and your questions. Stay tuned. Relief Factor loves hearing from pain-free customers and hopes they can help you next. One user, Bill, said, "I've been crawling under sinks and working long hours for decades. My back and knees took the punishment. I thought pain was just part of the trade. But Relief Factor surprised me. Within weeks, I was working without wincing. I could get down on the floor and get back up again without thinking twice." Bill knows hard work. He knows pipes, tools, and long days on the job. What he didn't know is how good life feels when pain stops tagging along. Relief Factor is 100% drug-free, and it targets the inflammation that causes pain. So you can move better, feel better, and actually enjoy life again. Try the 3-week quick start for just $19.95. Go to relieffactor.com or call 1-800-4-RELIEF. That's 800-4-RELIEF. Let's see if you're next in getting out of pain.
Welcome back to MK True Crime. I'm Phil Holloway along with my co-host Dave Aronberg. We'll get to our closing arguments here in just a moment, but first we have a question from Sanjita, who says, "Thank you for all you do. I just wanted to ask for something that would be amazing. If you could make a playlist on YouTube of the closing arguments segment, please. They are the best bits of the show, and I would love to easily binge them. I somehow feel cleverer after watching them and would like to be that concise too. Thank you very much, Sanjita. Well, today is your lucky day because guess what, Dave? Our intrepid team of producers have done just that, and they have made a specific playlist just of our closing arguments. And in that playlist, Dave, one thing that they will find here eventually is the closing argument that I know that you are teed up and ready to go with.
Oh, I am ready. And thank you, Phil and Sanjita. That's a wonderful request, smart. And thank you to our team for putting it together because it's our favorite part of the show. So you remember when I recently complained about being trapped near a passenger on a nighttime flight who wouldn't stop yapping the entire time? I honestly thought that was the peak of aviation misery because you're dealing with a 3-hour flight that was like a 3-hour root canal or perhaps a deposition of a corporate representative on something like document retention policies. That's the equivalent of sitting next to this guy. But it turns out the airlines have found a way to be even more brazen. They aren't just letting passengers steal your peace and quiet anymore. They're actually stealing your view. I don't know if you saw this, Phil, but I'm talking about the infamous Seat 11A. A recent report in the New York Times highlights how Boeing and Airbus both have planes used by major airlines that are missing a window in Seat 11A. Meanwhile, those airlines are charging premium preferred fees for those so-called window seats that are actually just blank plastic walls. Because of air conditioning ducts and electrical wiring, the window is completely blocked. Yet they still list it as a window seat. And here's the kicker. They still charge you extra for it. There are lawsuits pending over this. And although I have decried frivolous lawsuits and other rants, on this one, I'm with the plaintiff's bar. There's plenty of mens rea out there. The airlines know what they're doing here because they know the window isn't there, but they omit the material fact during the transaction to get you to pay the premium. In any other industry, we would call it a classic bait and switch or even theft by deception. But the good news is that if you luck out and get the aisle seat on that row, you won't have to worry about some inconsiderate person keeping the shade wide open while you try to snooze. That's because there is no shade, because there's no window. You know, someone once said, if you rob Peter to pay Paul, you can always count on the support of Paul. Yeah. So until the FAA starts handing out indictments for scenic fraud, my advice is simple. Do your due diligence and check those seat maps. Otherwise, you're just paying a premium to spend 3 hours in a staring contest with a wall. And trust me, the wall always wins. That's my rant.
Well, Dave, thank you for the heads up because I'm going to make a note of 11A because later this month I'm flying out west to bring home a new puppy named Duke Holloway, and I have to make sure that Duke is underneath the seat in front of me in the appropriate carrier, and I want to make sure that we're not in 11A because if I can't have all the room and see the things that I need to see, none of us are going to be very happy on the way back. And of course, everybody needs a happy puppy on the way back. All right.
Definitely.
Thank you very much, Dave. Look, I'm going to talk about, well, this is more about, say, lawyering and trial preparation, which is kind of a theme that I've kind of fallen into since we've been covering this Kouri Richins case. There's so many things we can learn about the law, about trials, trial preparation, and lawyering. I thought I'd take a minute to just talk with our audience about a device that we use. It's called a motion in limine, L-I-M-I-N-E. A motion in limine, if you're a lawyer going into a trial, this is your secret weapon for keeping things efficient and fair. And by the way, judges encourage these things because they want to get evidentiary issues sorted out before the trial starts. We could use some of that in this Richins case, by the way. So you absolutely need to use them. Look, jurors are ordinary people. They give up their time. They come in because they have to serve justice. The last thing that these folks want or need, and the last thing, honestly, that you want is a trial that drags on and on and on with sideshows, with irrelevant details, or with prejudicial bombshells that really shouldn't be heard at all. So without this pretrial motion in limine, your opponent might slip in something that's really toxic to your case and that really might not be admissible, like a client's unrelated past or perhaps some emotionally charged, but nevertheless irrelevant facts. And once it's out there in front of the jury, like was said earlier in this show, you can't unring that bell, or as we say in Atlanta, you can't take the skunk out of the jury box, or you can't put the toothpaste in the tube. It all means the same thing. And even if the judge sustains your objection at trial and strikes it and tells the jury to disregard it, the damage is done. The jury's already heard it. So that means more objections, more sidebars, more delays, and a lot of wasted jury time. So folks, if you're a lawyer and you're getting ready to try a case, whether it's a civil case or whether it's a criminal case, the judge is going to love you if you file these motions in limine ahead of time. You know most of the things that are going to come in. You can't address all evidentiary issues pretrial. Of course you can't, but you can address the big ones that you know are coming, and the jury and the judge are going to appreciate you for it, and it just may help you win the case. All right? So respect the jury's time. Use motions in limine. Your case and your jurors, as I said, will thank you. And with that, we'll leave it right here. Thank you very much for joining us today at MK True Crime. Thanks to my co-counsel and co-host, Dave Aronberg. I guess co-counsel is a good way to refer to my co-host these days. And of course, special thanks to our guest, Natalie Whittingham-Burrell. And to those of you watching, thank you for watching and listening. Thanks for listening. We'll leave it there. Have a great day.